We got a new ruling in breaking news. The 11th Circuit Court of Appeals, led by its Chief Judge William Pryor, has affirmed a $1 million sanction that was imposed against Donald Trump and Alina Habba back in 2022 by Judge William Middlebrooks in the Southern District of Florida. Yes, it took almost 3 years for that case to make its way up to the 11th Circuit Court of Appeals. They held oral argument on the 18th of November. And now, just a few days later, we've got a 36-page opinion that completely affirms what Judge Middlebrooks did and found. Donald Trump had brought a case to harass the Democratic National Committee, the Hillary Clinton, and about 8 or 9 other people by filing a 500-paragraph shotgun lawsuit alleging racketeering and other injuries, to which he said he was entitled to $24 million worth of damage. Instead, Judge Middlebrooks found famously now that the lawsuit was a political screed masquerading as a lawsuit. His words went through the paragraphs, found that it violated Florida law. It violated federal law and on his own, using the 2 powers that federal judges have. The inherent authority wearing a black robe that a federal judge has to impose sanctions for conduct that he or she observes before their court, and under Rule 11 of the Federal Rules of Civil Procedure, where a judge on their own, or based on a motion filed by parties, can impose sanctions. The $1 million was approximately the amount of the attorney's fees that were incurred by the various defendants who joined together in the appeal. And now, Judge William Pryor, joined by it's a 3-judge panel, joined by a Trump appointee and a Judge Brasher, who I know from the days in Miami, and Judge Kidd, who is a Biden appointee, got together and said, "No, you're going to have to pay the $1 million." And Donald Trump claims that he's going to pay the $1 million. But once again, Alina Habba, who is currently the interim U.S. attorney in New Jersey until the 3rd Circuit Court of Appeals makes their ruling to bounce her, which I think is coming any day now. And I think this is more wind at the sail of the 3rd Circuit. We just saw Lindsay Halligan get bounced as a U.S. attorney. I think Alina Habba is next. And I think the 11th Circuit with this new order just greased the skids to push Alina Habba out. I'm Michael Popach. Let's go over the case, why it's kicking around since 2022, what just happened in the last 7 or 8 days with the oral argument in Alabama, and why we just got the new order, and what does it mean? Donald Trump was trying to get some political credibility. So even before he ran in for office for the 2nd time, he was bringing all these lawsuits against the Pulitzer Prize Board because he didn't like them. New York Times because he didn't like them, and one of them was against Hillary Clinton and a whole bunch of Democrats and under racketeering and claiming they defamed him in 2016 because there was the Steele dossier and Russia collusion and the Durham report was being conducted and all of that. And then Donald Trump got all excited, like in the last year or so, year and a half or so. He tried to amend the record to say the Durham report is out. John Durham, the special counsel appointed by Bill Barr, it's out. See, a lot of things that I said were true. The Steele dossier and the Hillary Clinton campaign and Russia collusion and, so now he's adopting the Durham report. Well, if you're going to adopt the Durham report, if you're in for a penny, you're in for a pound. The Durham report effectively clears James Comey, the former FBI director. So which is it, Trump? The Durham. You're all excited about the Durham report because you think it supports your case and you're trying to get out from under $1 million in sanctions, but you don't like the aspect of it that cleared effectively James Comey. Yeah, you can't have it both ways. So here's what the 11th Circuit said. They said, we didn't even look at the Durham report. We saw the Durham report. It supports certain things that Donald Trump had said, but that is not what we're focused on. Effectively, they said that, once again, Alina Habba, who is handling the case, effed up procedurally in court. There's no other way to put this, that she waived a number of the arguments for the appeal. One of the arguments she tried to raise on appeal is, we didn't get a hearing about the sanctions, and the court said, you didn't raise that issue properly with the district court judge. Oh, well. We didn't get notice about the sanctions, and that should have happened under Rule 11. Again, something that you should have raised. Any practitioner who knew what they were doing down in Florida should have raised that issue with Judge Middlebrooks, because if it isn't raised, unless it's a fundamental appellate error that can be reviewed by the 11th Circuit directly, you got to waive it. You got to raise it, or it's waived. Here's what they say in the order. They agree with Judge Middlebrooks that the operative pleading in the case was shotgun, prolix, meritless, and therefore grounds to sanction them. This is what the court says. On page 27, the district court found that Trump filed a shotgun complaint to harass. It's not what it sounds like. A shotgun bleeding means you just fire out everything and anything. It's the kitchen sink. There's no concise statement as required by Rule 8 of the Federal Rules of Civil Procedure. There's no proper allegations and just an elegant presentation of your factual allegations. You just throw everything in the 800 paragraphs and you incorporate and reincorporate everything into the pleading. We call that derisively a shotgun pleading. The district court found that Trump filed a shotgun complaint to harass an abusive litigation tactic, which amounts to obstruction of justice because the person who has the suit against them has the right to understand what the suit is. Trump and Habba respond that every complaint claiming an interwoven racketeering claim is bound to include some shotgun elements. They also argue that sanctions should not be imposed for shotgun pleadings when the procedural correct response is dismissal without prejudice. Neither argument persuades us, says Chief Judge Pryor, 300 for the majority for the EU decision. First, we have recognized that racketeering plaintiffs are not exempt from the requirement to avoid shotgun pleadings. They then say on page 28, for example, Trump incorporates each of the preceding 633 paragraphs in his third count for injurious falsehood. Nothing prevented him from specifying the statements he contends are injurious falsehoods under this count. Second, Trump and Habba are wrong that because the ordinary remedy for shotgun pleadings is dismissal, shotgun pleadings cannot be evidence of bad faith, and they found that it was evidence of bad faith. On page 29, they found legal arguments that were raised against Hillary Clinton and others to be frivolous. Here's what they say there. Many of Trump and Habba's legal arguments were indeed frivolous. Even setting aside the tolling argument, the district court ruled that Trump brought several frivolous claims, including a malicious prosecution claim without a prosecution and a trade secret claim without a trade secret. Trump also appended 7 counts to his indictment, which did not allege any cause of action and which the district court found were the high watermark of shotgun pleadings. Trump and Habba gave us no reason to reverse the district court's ruling that these claims were frivolous. The district court also bolstered its finding of bad faith by pointing to Trump's litigation conduct in other cases. It found that the Trump's activity showed a pattern of misusing the courts. They argue that the court was wrong to consider his other litigation conduct, like we did it, but you shouldn't be able to consider it. The district court did not clearly err. The federal appellate court says on page 30, "We've affirmed a sanctions award based on a review of similar cases brought by a plaintiff as and his attorney." Trump and Habba cite no contrary authority. Although they tell us that the district court misread some cases, they never explain why the principle it drew from those cases is wrong. All they offer is the cursory statement that the other cases were brought for different good faith reasons. They also say the fee award for $1 million to the other side was proper. On page 30, the district court engaged in a detailed review of the sanctions request and considered Trump and Habba's line-by-line objections. Trump and Habba forfeited this argument by not raising the argument that there was a problem with the billing procedures of the other side at the trial court level. They also found that the district court did not abuse his discretions in issuing sanctions under Rule 11, finding that there were frivolous pleadings and that he did not judge Middlebrooks' abuses, discretion in declining to reconsider the judgment, and nothing about the Durham report changes their mind. This is the 11th Circuit, now just ruling that there's $1 million owed to the other side based on Judge Middlebrooks' findings in 2022. Maybe one of the problems Donald Trump has is nobody wants to represent him. Alina Habba is a terrible lawyer. She doesn't know what she's doing in most courts, let alone federal Florida court. She practices at best in New Jersey. And so they had that. Then Donald Trump hired his former high school military academy roommate, Peter Ticken, who was like a Fort Lauderdale insurance defense lawyer, to handle this case. That went terribly. And then at the last minute, he tried to bring in Alejandro Brurto 3 days before the oral argument, I guess, to argue the oral argument, who represented him in some defamation cases. I mean, it's just a mess, but that is a window into the mind of Donald Trump. We've seen him. He's gassed emotionally. He's out of power. He's literally out of power. He can't he stumbles down the stairs of Marine One. Can't make it across the lawn of the White House. He's done. He's toast. Put a fork in him. And I'm glad I'm able to report on this. While you're here, hit the free subscribe button. Help us continue to grow this pro-democracy channel. Until my next report, I'm Michael Popok. I'm Michael Popak, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Pope firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys, who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So, if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment, harassment, or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Pope firm today at 1-877-POP-IF or by visiting my website at www.popfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popak firm, fighting for your justice every step of the